Harper Paperbacks and Harper Monahan are proud to present How to Read the Constitution and Why by Kim Wehle. This is an Iliotibial band sleeps reading. Chapter 3. The Real Powers of the President. No More Kings. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. Note again, there is no definition of executive power. Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states when called into the actual service of the United States. How does this jibe with Congress's war power? And he shall have power to grant reprieves and pardons for offenses against the United States, except in classes of impeachment. Is the pardon power unlimited under this language? He shall have power by and with the advice and consent of the Senate to make treaties provided 2/3 of the senators present concur. What does treaties mean, and can the President do treaty-like things without Congress? And he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors and other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. Says nothing about the removal, although it's a critical presidential management tool. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of the law, or in the heads of departments. Section 3. He shall take care that all the laws be faithfully executed, and shall commission all the officers of the United States. Shall adjust the take care prerogative is mandatory. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Recall Chapter 2. Does this imply immunity from criminal process? We don't have a king, but the President can do a lot. The core function of the executive branch is to execute the laws, to identify individuals who violate laws passed by Congress, for example, and to prosecute those individuals in courts. Although the courts exist to ensure that the process is fair, the decision whether to investigate, arrest, and prosecute someone for allegedly violating laws rests exclusively within the executive branch. The Constitution thus gives the executive relatively extraordinary power to affect the liberty of specific individuals, and importantly, Article 2's mandate that the President can take care to execute the laws faithfully implies that the President must have enough authority to manage those who exercise executive authority. There are more than 73 federal agencies with law enforcement power. The thousands of people employed by those agencies ultimately answer to one person, the President. The President gets to do even more hefty things. He has the exclusive power to issue pardons for federal crimes. He can make treaties with the advice and consent of the Senate. And he is the Commander-in-Chief of the Army and the Navy of the United States, and of the militia of the several states. The President can appoint executive branch officers. He can pick and choose those who get hired to make important decisions within the scope of the executive power, and impliedly he can remove officers at will in order to effectuate his own political agenda and for other reasons. The President has other implied powers. He can order military action and engage in foreign policy on behalf of the United States, for example, even though neither of these functions is spelled out in the Constitution. Thus, although the President is not a king, nobody is directly above him in the chain of command either. Preventing American presidents from amassing the power of a king requires that the other two branches of government, Congress and the courts, be vigilant in checking the power that the President does have. Courts can exercise their checking function only in connection with individual cases. They have no say to whether, and if so which, individual cases come before them. As a consequence, Congress must embrace its vital oversight role if we, the people, are to keep presidential power in check. Executive power and the Take Care Clause. To understand the President's executive powers, let's start by asking a basic question. How does a person land in jail? First off, someone has to pass a law. Suppose that someone is the U.S. Congress, and suppose the law it passes states that whoever knowingly develops, produces, stockpiles, transfers, acquires, retains, or possesses any biological agent, toxin, shall be fined or imprisoned for life or any term of years, or both. The law does not mention any one individual by name. It applies to everyone, whoever, to be precise. It is a general, prospective rule that Congress enacted pursuant to its legislative power under Article 1. Now let's say John Doe violates the law by stockpiling anthrax in his garage. The FBI is tipped off and gets a warrant to search his residence, more on that later, and arrest him. The FBI is part of the executive branch. It's a sub-entity of the Department of Justice. Next, the prosecutor brings an indictment, a piece of paper containing criminal charges, before the grand jury. A grand jury is a group of individuals tasked with considering documents, testimony, and other evidence presented by prosecutors regarding an individual or entity's bad deeds, and deciding whether the party should be charged with a crime. It has more members than a regular jury, which decides facts. The grand jury has the power to subpoena documents and testimony, to force people to show up and explain what they know. But without an attorney present, if a subpoena recipient refuses to comply, she can be sent to jail until she changes her mind. So without that particular cop on the block, i.e. the subpoena power, nobody would bother to heed the grand jury's request. The prosecutor couldn't collect the evidence she needs to try and convict bad guys. And the streets would be less safe as a result of criminals running around with the knowledge that they can't really be held accountable. Let's assume that the grand jury determines that there is a probable cause to indict John for violating Congress's statute banning the stockpiling of chemical weapons such as anthrax. John is prosecuted for that crime in court. The prosecutor is part of the executive branch, an assistant U.S. attorney employed by the Department of Justice, to be precise. The jury, a petit jury, which is smaller than a grand jury and serves a different role of convicting or acquitting a defendant after a trial, sits in a federal courtroom. A federal judge, a member of Article 3's judicial branch, presides over the trial. The trial's function is to resolve what amounts to an individual dispute between the government, represented by the Department of Justice, and John Doe. The prosecutors present much of the same evidence that went to the grand jury, and maybe more. That's because the standard for conviction, the rubric against which the petit jury must weigh the government's evidence, is much higher at trial. Instead of a probable cause, the jury must determine that the evidence presented by the prosecution is beyond a reasonable doubt that John violated the statute. John is convicted. John goes to prison. He is escorted there by a U.S. Marshal, a member of another federal law enforcement agency within the Department of Justice, and thus within the President's chain of command. The Federal Bureau of Prisons, still another arm of the executive branch, runs the prison. We can conclude from this scenario that the executive branch does a lot, and that Congress doesn't do much. Congress essentially sets the toy boat to sail on the pond by passing a law. Then, for the most part, Congress is done. It can't take action against a particular individuals. Congress needs the executive branch to bring individual cases. Without police and prosecutors, laws passed by the legislature are nothing more than words on a page. The president must take care that the laws are faithfully executed. In Article 2, the Constitution says shall. It does not say may. But such apparent rhetoric, clarity quickly confronts a roadblock. What does taking care mean? We know that Congress creates federal laws. We also know from our hypothetical that the executive investigates, makes arrests, prosecutes, and jails those convicted of violating the laws. Whatever law execution is, therefore, it must include those steps in the criminal justice's process, because Congress expressly cannot do them in the president's stead. But it is unreasonable to suggest that shall necessarily requires that the executive branch prosecute every single conceivable violation of the laws. Indeed, one reason we might elect a particular presidential candidate over others is that she promises to be tough, or relatively lax, on a particular category of crime. Upon taking office in 1981, for example, Ronald Reagan continued President Nixon's War on Drugs initiative. Instead of worrying out drug suppliers from other countries, he deliberately focused on the internal demand for drugs, promising to arrest, prosecute, and jail more users on the rationale that it's far more effective if you take the customers away than if you try to take the drugs away from those who want to be customers. Some criticized Reagan's zero-tolerance policies as having a racially discriminatory impact, but there is little question that it produced more drug arrests, convictions, and incarcerations, the very kinds of things that the executive branch controls. By contrast, when President Bill Clinton took office, he was criticized for allegedly planning to effectively abandon leadership of America's anti-drug effort, cut federal enforcement personnel, and seek to pour over $300 million into a national drug treatment system instead of prosecuting drug crimes. Yet, as with Nixon and Reagan, Clinton's decisions regarding drug enforcement priorities fell squarely within the president's constitutional prerogative. Despite its mandatory language, the Take Care Clause reasonably contemplates that presidents will decide which crimes and alleged violators shall be the focus of law enforcement's efforts. But does that mean that the president can completely ignore an act of Congress that declares certain behavior unlawful or regulates private conduct in some other way? Can the president simply decide that a statute is dumb or immoral and refuse to enforce it entirely, rendering it dead? Some scholars argue no. In a grammatical form, the Take Care Clause is an imperative. It instructs or admonishes the president to take care. Among other sources, they cite in support of the 1828 edition of Noah Webster's American Dictionary of the English Language, which explains the meaning of the noun care as including caution, a look into, regard, attention, or heed. Thus the argument continues. The Take Care Clause is naturally read as an instruction or command to the president to put the laws into effect, or at least to see that they are put into effect without failure and exactly. What this means is that the president cannot suspend the law of the land at his whim, as British kings had. To do so would be akin to giving the legislative branch the proverbial finger, to treat it as if its role were constitutionally irrelevant. President Barack Obama's Deferred Action or Childhood Arrivals program was criticized for that very reason, i.e. for perpetually ignoring the president's take care mandate while at the same time undermining the rule of the law established by Congress. For years, federal immigration officials lacked clear guidance from Congress regarding what to do about so-called dreamers, people who are brought to the United States as children by their parents, in light of laws banning the unauthorized entry of people across the United States borders. First introduced in 2001, the DREAM Act would have enabled permanent residency for certain people within the Dreamer umbrella. To date, the bill has been reintroduced every year since 2001 and repeatedly been killed. In the wake of congressional inaction, Obama in 2012 issued a memorandum called Exercising Prosecutorial Discretion with respect to individuals who came to the United States as children. As its title suggests, the memo set forth criteria for the Department of Homeland Security to employ in deciding whether to institute removal proceedings for dreamers. The rationale for declining prosecution was that, as a general matter, these individuals lacked the intent to violate the laws. The memo went further, however, and gave deferred action to certain applicants, which comes with the government's authorization that they can work, a grant that is not a clear exercise of prosecutorial discretion, but the memo's primary justification that not enforcing immigration laws against dreamers was that those who execute the law, i.e. people answerable to POTUS, which is shorthand for the President of the United States, get to decide whom to prosecute. We all understand this concept from basic life experience. The cop hiding in the bushes gets to decide which of several motorists to pull over for speeding. In offering a plea deal to a first-time heroin possessor, the prosecutor gets to decide whether to introduce parole or jail time. Same goes for a sitting president's exercise of the executive power. Pragmatically speaking, therefore, it is impossible to view the Take Care Clause as mandating 100% enforcement of all crimes for wrongdoers. The resources do not exist to implement such a mandate. There are a finite number of law enforcement agencies and prosecutors to go around. The Constitution's use of the word shall can't mean shall in the very strictest sense. At a minimum, scholars agree that the president has no duty to enforce statutory law or treaty provisions that he reasonably and in good faith considers to be unconstitutional. This is undoubtedly correct. The Constitution is the highest law of the land. A federal statute that required the FBI to jail anyone who tweets would violate multiple provisions of the Constitution, including the First Amendment and the Due Process Clause. The president would be duty-bound to refuse to enforce it. A more realistic approach to the prosecutorial discretion under the Take Care Clause might be to acknowledge that although presidents can decide not to prosecute on a case-by-case basis, they must at least prosecute some people under every law that they are required to execute. In other words, the president cannot categorically refuse to enforce an act of Congress, but he can make decisions within that outer boundary. Of course, the question then becomes how many prosecutions are required in order to satisfy this view of the separation of powers. 1, 10, 100? Would the president need to pursue 1,000 prosecutions in order to avoid a categorical constitutional failure to enforce a criminal law? To engage in this mathematical exercise seems ridiculous on the face, and completely at odds with any reasonable meaning of the words take care, which can't be about counting heads. Other scholars argue that the core purposes of prosecutorial discretion, justice, mercy, and societal utility all necessarily require the president to make independent judgments about the wisdom of prosecution, particularly when it comes to deprivations of liberty. This competing idea of prosecutorial discretion indicates that we elect presidents with the understanding that they will make independent decisions about law enforcement, including whom to prosecute or not to prosecute. That's what elections are for. As told, there is no clear answer on how to read the Take Care Clause. Suffice it to say that when headlines holler, the president violated the Constitution, readers can be wary. Like most constitutional issues, the meaning of executive power is not black and white, but many variances of gray. Agencies. A few words about federal agencies are in order here. Agencies are technically part of the executive branch and thus within the president's chain of command. Agencies are extraordinarily important to American life, yet few people have any clue what they do, how they get the power to do what they do, and how the Constitution makes sure that they are held accountable. Agencies do what all three branches do. They create laws, they enforce laws, and they adjudicate laws. They make many, many more laws than Congress does, yet the people who run agencies are not elected. They decide individual disputes, but they are not created under Article 3, and the jurisdictional sandbox for courts don't apply to them. They enforce laws too, kind of like prosecutors, but without the criminal implications, i.e. they can't send people to jail. They do all three things, yet there is no fourth, hybrid branch of government in the Constitution. It turns out that a number of lawsuits were filed in the federal courts nearly a century ago that complained about the newfound agencies having too much power that rightfully belonged to the other branches. The Supreme Court found ways to condone them, and even a solidly conservative Supreme Court would be hard-pressed to dismember the entire administrative bureaucracy, save for its functions that are exclusively executive in nature. Practically speaking, it wouldn't be feasible. Congress can't do it at all. It doesn't have the capacity, the expertise, or the political willpower. It's easier to shrug off to an agency which is politically accountable via the president because voters don't fully understand that a vote for a president is a vote for his top officials in federal agencies too, and those people aren't even chosen until after the election. Because the president appoints heads of agencies under Article 2 and has implied powers to remove them, agencies answer to the president. But Congress creates agencies pursuant to the necessary and proper clause. Most agencies get their very own creation statute. Congress also gives agencies their powers. The Environmental Protection Agency has the power to enforce the Clean Air Act, for example, but not the power to enforce the Federal Trade Commission Act. Congress gave that power to the Federal Trade Commission alone. So imagine that Congress passes a statute, let's call it the National Internet Crimes Against Children Act, NICAC, which directs the Federal Communications Commission, FCC, to implement a national strategy for preventing online child exploitation and protecting children from online sexual predators. The NICAC is full of policy gaps. The statute leaves it to the FCC to come up with the actual language spelling out the precise rules. The NICAC directs the FCC to work with a number of other agencies, such as the DOJ, the FBI, and the Department of Homeland Security, U.S. Immigration and Customs Division, to formulate policies that take into account several related considerations, such as the need of law enforcement, the legal expertise of agency officials involved in child pornography sent through the mail, collaboration with overseas regulators and law enforcement partners, and private sector advancements in online technologies. There are many possible reasons why Congress left blanks in the NICAC for the FCC to fill in. It might be that the highly polarized legislature could not agree on the details of the policy, and its congressional supporters were aware that if anything was to be passed, the only way to do it would be with broad brushstrokes. Members could also have been eyeing the next election and realizing that taking a position on particular elements of a policy, such as banning or not banning certain kinds of online pornography, could be prompt an outcry from industry, concerned parents, or some other constituent groups, not to mention First Amendment litigation. or Congress might have insufficient expertise to craft the highly specialized laws. Whatever the reason for the FCC's legislative assignment, the task is a daunting one. One last global point about federal agencies, and it's an important one. There is a separation of powers problem with agencies enacting regulations. Another thing that agencies do. Regulations are as forceful as laws passed by Congress itself. In this sense, a regulation is just another word for a law. To someone seeking to apply the Constitution's plain language, agencies' roles as lawmakers, as well as the laws that result from the regulatory process, are unconstitutional. The legislative power is vested in Congress, and the vesting clause does not hedge or equivocate. Justice Antonin Scalia rationalized it in this way. When agencies pass regulations, they are not making laws. They are interpreting them, which is an executive function. Of course, interpret is nowhere in the Constitution. At the end of the day, it is a fact that agencies make laws, so Congress effectively created a statutory employee manual for agencies to follow when they make laws. It was enacted in 1946 for the precise objective of keeping agencies from overreaching when they used their newly minted New Deal powers, and it's known as the Administrative Procedure Act, APA. The APA contains an elaborate process that agencies must follow when making laws, euphemistically known as rules or regulations, that have the same force as the statute passed by Congress. The idea behind the process is to give lots of advance notice to the rule of the public and to invite anyone who might have a stake in the rule to weigh in with written comments that are directed at the people within the agencies responsible for drafting the rule. Think again for a moment about the difference between policy and politics addressed in the introduction. Good policy is not purely ideological. It is formed by accounting for lots of information, different sides of the coin, so to speak, and reaching a decision that the policymakers conclude is the very best one. All things considered, an agency regulation reflecting such a policy decision will not be perfect. But maybe we can sleep at night knowing that agencies must at least make rules that are reasoned and supported by sound and comprehensive information, because the rules have to be under the APA. There are numerous additional statutes that agencies must comply with before they can get regulations on the books. In fact, many scholars have bemoaned that so many statutory wickets bog down the process that paralysis by analysis ensues and little gets done. Suffice it to say that agencies are the tail wagging the federal government's dog. Yet relatively few people know much about what their powers are and how they are kept from going off the rails, so to speak. Ozzy Osbourne reference. Executive orders. Alas, there is yet one more complicating factor in the seemingly straightforward question of what it means to execute laws. The Trump presidency has made headlines around this wrinkle in the executive versus legislative power struggle, the executive order. The Constitution does not refer to executive orders, and there is no statutory authority for them, but historically any writing by the president giving directives to subordinates constitutes an executive order. In 1873, President Ulysses S. Grant issued an executive order setting forth guidelines for issuing executive orders, which exist today in revised form. The order must go to the Office of Management and Budget, and then to the Attorney General for approval before it is signed by the President. Executive orders have the force of the law, like statutes and regulations. The sources of their constitutional authority are our old friends the vesting clause and the take care clause under Article 2. Under a strict construction of the Constitution, executive and legislative power must mean different things. Yet presidents long before Trump have used executive orders to create binding rules of general application that govern future behavior, which is our working definition of law. Executive orders now number more than 13,000. President Abraham Lincoln suspended the writ of habeas corpus and issued the Emancipation Proclamation by executive order, more on habeas later. President Dwight D. Eisenhower desegregated schools. President John F. Kennedy and Lyndon B. Johnson barred racial discrimination in federal housing, hiring, and contracting. There can be little question, therefore, that presidents have made laws by executive order without complying with Article 1's bicameralism. 2 houses of Congress must approve, and presentment, the president must sign off, mandate. Because the guidelines governing executive orders are not statutory or constitutional, the presidents are free to ignore them, and presidents can amend or reverse predecessors' executive orders, as President Clinton did with President Reagan's executive order banning the use of federal funds for advocating abortion. Because, tongue twister alert, The president is theoretically exercising executive power by issuing an executive order. Congress can amend the laws relating to an executive order, but the president can also veto any laws that override his executive order, as was seen with the Trump immigration orders, which were initially stalled on constitutional grounds by federal courts. Judges play an important role in making sure that presidents comply with the Constitution in issuing executive orders. At the end of the day, Congress has a number of other ways to ping the executive branch if it impedes legislative powers. It can impede the president, who has presided over the unconstitutional agency activity, or an agency head, revoke the agency's legislative charter, hold hearings to find out what the agency is really up to and make public hullabaloo, or tighten the agency's budget so there simply aren't enough resources for it to continue its bad deeds. Indeed, purse strings are how Congress checks a lot of what the federal bureaucracy does, or Congress can do nothing. Congress can sit by and let things happen in the other branches. That might be a bad public policy, unlawful, or even unconstitutional. When Congress, as the constitutional cop, is effectively off duty in its own accord, there is little voters can do other than blast members' offices with angry messages and barring movement on that tactic. Hold them accountable at the voting booth in the next election. Appointment and removal. A discussion of the president's power to appoint and remove officials warrants a bit of context regarding what it means to have a single person at the head of the executive branch. At the Constitutional Convention in Philadelphia in 1787, the delegates rejected the state of New Jersey's proposal for an executive council composed of multiple people. They instead chose a unitary executive, the theory being that a single president would be able to act swiftly, uniformly, and decisively. A unitary executive structure also meant a clear line of accountability. To quote President Harry Truman, "If the buck stops with the president, then the public will know who to blame if matters within the president's chain of command go awry." And things do go awry. In December 2006, that's my birth month and year. In December 2006, George W. Bush's Department of Justice ordered the dismissal of 7 U.S. attorneys, some of the federal government's top criminal persecutors. The press was all over it. Congress conducted investigations into whether the dismissals were politically motivated. Many people were shocked by the apparent secrecy around how the decision to fire was made and by whom. Yet, as explained in this section of the book, the Constitution is clear. President Bush acted within his constitutional authority in firing these people, even if the motivation was purely political. President Nixon has tried the same maneuver more than 30 years prior. Attorney General Elliot Richardson appointed an independent special prosecutor to investigate in the June 1972 break-in at the Watergate Hotel, during which 5 Nixon affiliates were caught trying to bug the headquarters of the Democratic National Committee. When the special prosecutor Archibald Cox issued a subpoena to Nixon for copies of his taped conversation from the Oval Office, the president refused to comply. An attempt to negotiate a compromise with Cox failed. Nixon ordered Richardson to fire him. Richardson refused, resigning in protest, so Nixon ordered Deputy Attorney General William Ruckelshaus to fire Cox. Ruckelshaus likewise refused and resigned. Nixon then turned to the Solicitor General Robert Bork, who finally complied. In a dramatic next act, the White House sent FBI agents to seal off the offices of Cox, Richardson, and Ruckelshaus. After this Saturday night massacre, public and congressional opinion shifted against the president, and talk of impeachment increased. Relenting to pressure, Nixon appointed a new special prosecutor, Leon Jaworski, who ultimately obtained the tapes after taking the issue to the Supreme Court, which ruled against Nixon's claims of executive privilege. Nixon resigned on August 8, 1974, my parents' birth year. Nixon lost the ultimate power struggle, but not because he acted unconstitutionally. Donald Trump dismissed Acting Attorney General Sally Yates for refusing to enforce his controversial travel ban executive order. He also fired FBI Director James Comey. Yet, like Bush and Nixon before him, Trump was acting within the purest of his constitutional prerogatives to do so, setting aside whether his possible reasons for doing so, i.e. hampering the special counsel's probe, separately constituted obstruction of justice. When the president fires a prosecutor, he pulls another crucial lever of the presidential power, one lodged in the Appointments Clause. Recall the ice cream store hypothetical. The owner wants to run a successful business that turns a profit. To do that, he must establish a coherent structure of accountability, which includes mechanisms for rewarding good behavior and accounting for bad behavior. The very threat of removal keeps employees honest, but hiring decisions are crucial as well. In 2018, basketball player LeBron James signed a stunning $154 million contract with the LA Lakers, presumably because he was considered the best person for the job of helping win basketball games. Although members of a president's cabinet don't make that kind of money, they do wield tremendous discretion to shape matters of national or international importance. A president picks his cabinet with an eye towards achieving his political and policy agenda. He wants people who will implement the objectives that he campaigned on and do it effectively. Failing that, as for an ice cream shop owner, the president needs to be able to fire his team if they are not performing. For its part, the Constitution contains very few clues as to what the framers intended the executive apparatus to look like beyond the president and the vice president. What the plain text does envision are executive departments headed by principal officers who are appointed exclusively by the president with the advice and consent of the Senate. The Constitution also allows the president to require the opinion in writing of the principal officer in each of the executive departments. So the text contemplates that the federal government includes executive officials under the president. It also includes such officials to an executive department and indicates that there will be a principal officer, the principal officer emphasis mine, in department whom only the president can appoint. In addition to officers, the president appoints ambassadors and Supreme Court justices. The language of the Appointments Clause is comparatively straightforward, but not without glitches. Its meaning gets tricky when Congress mucks around with the president's ability to decide who will run the agencies it creates by statute. Keep in mind that the time an agency's name has the word commission in it, the Federal Trade Commission, or the Securities and Exchange Commission, it means that the statute creating the agency, Congress rejected the unitary boss design and instead established a panel to head the agency. In most cases, when Congress does this, it also includes limits on a new president's ability to appoint and remove members of that panel. If the idea is to let the ice cream shop owner make the hiring and firing decisions that it will best enhance his ability to run a successful business, Congress's structural novelties in this regard are a potential problem for the president's capacity to run the executive branch in the way she promised the electorate during the campaign. Note, however, that the Constitution is silent about whether the president has the exclusive power to remove appointees. Someone espousing a strict reading of the Constitution might therefore have to hold his nose and tolerate congressional removal of executive officers. The Constitution would not clearly forbid that. Of course, such a result would create shameless political gamesmanship and ultimately mayhem, with the president beholden to Congress for virtually every executive decision, for fear of having her cabinet gutted. Many years ago, the Supreme Court reasonably construed that the Appointments Clause as contemplating a reciprocal power to remove appointees, although it later found that Congress can constrain that power. Otherwise, the court resonated, how could the president follow the Constitution's mandate that she take care that the laws be executed? The president's power to appoint and remove executive branch officers gained renewed importance under the Clinton and Trump administrations. After the Saturday Night Massacre, Congress decided that Nixon's attempts to stymie the special counsel reflected a serious threat to the integrity of the government. Congress passed a statute that cut out the prosecutorial function from the president's job description in certain circumstances, most notably if the president himself, as well as other high-level officials, was being investigated for possible violations of federal law. The Ethics Government Act of 1978 lodged the power to appoint a special prosecutor, known for purposes of the statute as an independent counsel, in a panel of 3 federal judges. The independent counsel could only be removed by impeachment or by the Attorney General for substantial improprieties. In the case Morrison v. Olson, the Supreme Court found the statute constitutional over a famous dissent by Justice Scalia on separation of powers grounds, even though the statute took quintessential constitutional powers, investigation and prosecution, away from the president. Perhaps in recognition of the statute's inherent flaws, Congress did not renew it. Instead, the Department of Justice passed internal rules that set forth certain terms and limitations for the appointment and removal of a prosecutor charged with investigating the president. But internal rules are not the same as a statute. If a president wants to fire a special prosecutor, e.g. Robert Mueller, who is investigating him, he can probably do so at least as a constitutional matter, under the Constitution's implied removal power. Thus, while President Trump dangled the threat of termination over Special Prosecutor Mueller and the Deputy Attorney General who appointed him, Rod Rosenstein, the very struggle for presidential accountability that ended Nixon's presidency was put on the table again. Pardon power. Now, a few words about the pardon power. The president's power to pardon those convicted of federal crimes theoretically functions to check potential abuses by other parts of the government. How? By relieving individuals of the full effects of a criminal judgment obtained through the judicial branch. In theory, it can also convey to Congress that a criminal law is unfair or has been used unfairly. The pardon power operates as a check on overzealous prosecutors too. Of course, federal prosecutors answer to the president, but in reality they also function with a measure of independence from the president. This, once again, is not a rule found in the Constitution itself, but a best practices standard for prosecutors. Otherwise, the federal system of criminal justice could devolve into one that hinges on the political predilections of the president, who would be motivated to serve up justice to friends and come down hard on foes, despite the facts and the law. A suggestion that the pardon power is affirmatively absolute is troubling, however. Article 2, Section 2 of the U.S. Constitution states that President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. A keen lawyer would ask, where are the gray areas in this language? To be sure, the claim that the pardon power is unfettered relies on the term shall. In common language, shall is the equivalent of mandatory, suggesting that the power must go to the president alone. But does that also mean that the power is unlimited, in addition to suggesting that no one else can exercise it? Maybe not. The Constitution's use of shall in other places, such as Article 1, Section 1 statement that all legislative powers herein shall be vested in a Congress of the United States, has been riddled with holes. Kids are taught in schools that legislative makes laws. But as we've seen, so do federal agencies. And when federal agencies make laws, those laws function with the same power and authority that acts of Congress do. So we know that shall does not have one definitive meaning under the plain reading of the Constitution. Historically, to be sure, presidents have widely exercised the pardon power without courts jumping in and telling them that they violated the Constitution. In a 1925 case called Ex parte Grossum, the Supreme Court upheld President Calvin Coolidge's issuance of a pardon that reduced a man's sentence for violating a federal court's prohibition on the sale of alcohol. In 2017, President Trump pardoned former Arizona Sheriff Joe Arpaio, who likewise violated a federal court injunction, which in lawyer speak is simply a directive that someone do something or stop doing something. Does that mean that the pardon power is absolute? Not necessarily. In Schick v. Reed in 1974, my parents' birth year, the Supreme Court upheld the president's power to issue a pardon that reduced a death sentence to life in prison, but added that considerations of public policy and humanitarian impulses support an interpretation of that power, which does not otherwise offend the Constitution. Emphasis mine. Under Schick, therefore, the same keen lawyer must ask whether a pardon offends some other provisions of the Constitution. This is exactly the right next question. When it comes to laws, the Constitution is the boss of the boss. It is the boss of everyone who works for the federal government, including Congress. It is the boss of any legislation it issues, which means that the Constitution trumps, no pun intended, a contrary law. Again, the Constitution's packaging did not come with a bluggadin or electric fence. It is merely a conduit for self-governments. The people's agreement to a set of rules that bind to those who exercise power that ultimately resides in we the people. The Constitution is the boss of the president too, to the extent that it reinforces the people's social contract for governance. The pardon power articulates no exception. Commander-in-Chief. The Constitution sets up a micro-struggle between Congress and the President when it comes to the power to control wars. It does not make clear who is the ultimate boss here. As a result, we've seen a quiet accumulation of power in the presidency. Imagine that you do interior design. You are on a conference call with a customer who is looking for advice about renovating a kitchen. The company boss told you to work with Joe on the project. You and Joe were hired around the same time. You have respect for Joe and plan to deftly manage the client meeting by focusing on broad goals versus specifics. Once on the call, you learn for the first time that Joe has drafted a detailed kitchen renovation plan and forwarded it to the client in advance of the call. Everything from finishes to appliances to layout to pricing is already in the document. which the client accepts as the recommendation of the firm. On the call, your role is immediately marginalized because Joe has established himself as the lead. Now, put yourself in Joe's shoes. On a much larger scale, imagine that you are a U.S. president, and there is a brimming military crisis in a fictitious country rich with oil. The democratic president of that country has been toppled by a terrorist coup. Your own re-election is in 6 months, and you want to make a show of strength to convince the voters that you are a strong leader. You order the U.S. military to carry out airstrikes in the hope that they will curtail the growth of the new terrorist regime. The strikes lead to hundreds of documented civilian deaths. You, like Joe, do not consult Congress at any point during the conflict. As noted in Chapter 2, Article 1 grants Congress the power to declare war, but Article 2 names the President the Commander-in-Chief of the Armed Forces. So who answers to whom? Congress or the President? When the President launches airstrikes, is that an act of war that requires an advance congressional declaration, or is it an executive decision to direct military operations within the meaning of Article 2? Who controls war matters is, in other words, a classic chicken and egg problem. An act of war could be confined to something formal, such as what occurred after the bombings of Pearl Harbor, to authorize America's entry into World War II. Alternatively, the Constitution could be read as treating Congress as having declared war whenever it approves ongoing funding for the armed forces, thereby leaving the President free to execute the declaration as she sees fit. The Constitution doesn't weigh in either way. For the most part, the Supreme Court has steered clear of this debate on the theory that it is a political question. The court has identified some claims of unconstitutional government activity so volatile and politically toxic that they should be left to the political branches. The idea is that voters should rule on such issues, e.g. foreign affairs and the process for ratifying constitutional amendments. Perhaps unsurprisingly, the political question doctrines test is highly subjective. It is not grounded in constitutional text, and it has fluctuated over the years. It exists to give judges an out if there is something so politically thorny that they don't feel that it is their place, as unelected government officials, to touch it with a 10-foot pole. The conflict over the constitutional war powers is one of those things. Aware of this power struggle, Congress in 1973 passed a statute addressing two questions left open by the Constitution. First, what is an act of war that only Congress can trigger? Second, can the President use American troops on his own? The statute is called the War Powers Resolution, and it limited presidential power in response to the unpopular Vietnam War. The President may introduce armed forces only pursuant to 1. A declaration of war, 2. A specific statute, or 3. National emergency created by an attack upon the United States. The law also requires that the President report to Congress and withdraw troops after 60 days if there is no formal authorization of war by Congress, but it hasn't been enforced. The statute has been criticized as an unconstitutional constraint on the President's commander-in-chief power. Alternatively, it has been justified as a necessary check to address a constitutional gap that could otherwise edge the presidency towards monarchy, and without it, the argument goes that Congress's war powers under Article 1 would, if they haven't already, become null and void. As a practical matter, there is no cop on the block willing to enforce Article 1 in this regard. To make its power to declare war meaningful again, Congress might have to cut off funding to the military until the President complies with the Constitution and the War Powers Resolution. This won't happen, at least anytime soon. The power to wage a war is an area where the relative power of the presidency has steadily increased since the founding of America. Treaty, another area that creates a constitutional clash between Congress and the President in the realm of foreign affairs. The Constitution gives the President the authority to make treaties, with the consent of 2/3 of the Senate. If a treaty conflicts with a statute, the Supreme Court has held that the most recent one controls. Although Congress ratifies treaties, the President can do a treaty light, without Congress's buy-in. Presidents can negotiate what is called an executive agreement, which, like a treaty, is between the United States and a foreign country. There is no substantive distinction between the two. An executive agreement can accomplish precisely the same things as a treaty, but the former does not require the Senate ratification. And never in American history has the Supreme Court declared an executive agreement unconstitutional as usurping the Senate's treaty-approving function. President Franklin D. Roosevelt loaned Great Britain 50 naval destroyers during World War II and recognized the Soviet Union for the first time by executive agreement. In 1981, President Jimmy Carter struck an agreement with Iran to lift a freeze on Iranian assets in exchange for the liberation of American hostages in Tehran. The only meaningful limits on the president's ability to negotiate what amounts to treaties with foreign nations must be found elsewhere in the Constitution. A president could not agree, for example, to implement and enforce a ban on news that criticizes Syrian President Bashar al-Assad in exchange for an agreement to cease the commission of war crimes against his own citizens. Such a deal would violate the First Amendment, for starters. At the end of the day, there is no king, but as construed by the Supreme Court, the U.S. Constitution has tolerated some king-like powers inherent in the office of the president. Few Americans realize that many of these powers, including those surrounding foreign affairs, do derive from an unambiguous reading of the plain language of the Constitution. It is of critical importance that Congress and ultimately the voters keep a close eye on the escalation of presidential powers under both Republican and Democratic presidents. Once in the toolbox, they are there to stay. And that is Chapter 3 of How to Read the Constitution and Why by Kim Wehle.